Welcome to The Explainer. Today, we're tackling a question that trips up just about everyone, from law students cramming for exams to even seasoned lawyers in the courtroom. We're talking about Section 79 of the Judiciary Act, and we're going to solve the federal evidence puzzle. So let's just put you right in the middle of it. You're in court. It's a federal matter. Now, which set of evidence rules do you use? The states? Or the Commonwealth's? You'd think that would be a simple question, right? But because of how Australia's court system is structured, it gets complicated, fast. Today, we're going to make it simple. And it really is a puzzle. The reason is something called federal jurisdiction. That's basically the authority to hear cases about federal law. But here's the kicker. It's not just the high court or federal court that have this power. Your local state courts can have it too. And that creates this fascinating, kind of weird situation. You've got a state court in a state courthouse, but it's wearing its federal hat for the day. So which rules does it follow? The states? The Commonwealth's? That's the core problem we're going to solve right now. Okay, so let's bring in the first major piece of our puzzle. This is Section 79 of the Judiciary Act. This is our starting point. It gives us the general rule for how to handle things like procedure and evidence when we're in federal jurisdiction. Now, the whole idea behind Section 79 is based on a classic legal principle called lex fori. It sounds fancy, I know, but all it means is the law of the court, as in the law of the physical place where the case is being heard. The logic is simple. Procedural stuff should follow the local rules of the courthouse you're in. And here's the heart of it, right from the act itself. Lawyers call Section 79 a pickup provision, and that's a great way to think about it. It basically tells any court dealing with a federal matter to just look around, see which state or territory it's in, and pick up that state's laws on procedure and evidence. Think of it this way. The federal case is a guest in the state's house. And when you're a guest at someone's house, you follow the house rules, right? So a federal case being heard in a court in Perth will, as a general rule, use West Australian evidence law. Simple. Well, mostly. And here it is. The twist. If you're studying for an exam or you're out there in practice, this next part is absolutely the most critical thing to get your head around, because Section 79 is not the end of the story, not by a long shot. Let's just stop and look at these 5 words. Except as otherwise provided. It sounds so harmless, doesn't it? But these 5 words are a complete game changer. They create a massive, massive exception to that general rule we just talked about. So what this really means is that Section 79 is just setting a default. It's Plan B. It says, go ahead, use the state law, unless a Commonwealth law says to do something different. And that sets up a very clear pecking order. If there's a specific Commonwealth rule that applies, it always wins. So what does this otherwise provided look like in the wild? Well, it could be something in the Constitution itself or any other federal law. But the big one, the one you'll see all the time, is the Commonwealth Evidence Act of 1995. If that act has a rule on a specific evidence issue, it doesn't matter what the state law says. The Commonwealth rule trumps it. It just bumps the state rule right out of the picture. Okay, theory's great, but let's look at how this actually works in a real case. A high court decision shows us this whole hierarchy playing out perfectly. So get this, the high court is sitting in Adelaide. One of the parties tries to use a South Australian law that says you can submit a written statement as evidence. Makes sense, right? They're in SA. But wait, there's a Commonwealth law, the High Court's own Procedure Act, that says something completely different. It says evidence has to be given orally, in person. It's a direct conflict. One says written is fine, the other says it has to be spoken. So who wins? The Commonwealth law. The state law didn't even get picked up, and that written statement was thrown out. All right, so after all of that, what's the bottom line? How do you actually apply this? We can boil this entire thing down to a very simple, very practical, 2-step process. This is it. This is the crucial takeaway. For any evidence problem you ever face in federal jurisdiction, this is your mental checklist. Step 1. You always start by looking at the state law. That's what Section 79 tells you to do. But, and this is the part you can never forget, you must then do Step 2. Always check for a Commonwealth override. Ask that question, is there a Commonwealth law that says something different? If the answer is yes, you follow that Commonwealth law. End of story. And this whole thing leaves us with a final, pretty big question to chew on. We've just spent this time untangling a really complex, layered system where lawyers and judges are constantly having to jump between different sets of rules. And you have to wonder, is this really the most efficient way to do things? Wouldn't it be simpler, maybe even fairer, to just have one single Uniform Evidence Act for every court in Australia, state or federal? It's definitely something to think about. Thanks for joining me on The Explainer.